Hi, and welcome to another episode of NCBA's Coffee Break, where we bring you insights from the brightest legal minds. I'm Nathan Willner, your host, and I'm excited to talk with our guest today about an area of law that some may find unique, but that is very much a core part of the creditor's rights legal practice, Replevin. We're joined by two of the three presenters of an upcoming Connect Conference CLE session titled Replevin, I want my collateral back, and here's an effective and efficient legal way to get it. Attorneys Tom Canary and Frank Venenzio. Uh, their colleague John Sperati couldn't be with us today due to a court appearance, but we look forward to having him on a future episode. The session that all three, Tom, Frank, and John, are going to be presenting sounds really exciting. It's designed to equip the attorneys, lenders, legal professionals with tools to recover wrongfully held property using Replevin, an often underutilized but highly effective legal remedy. So, listeners, grab your cup of coffee. We're going to hear a little bit more. And I'm going to kick it off. I'm going to send out the first question to Frank. Let's start with the basics. What exactly is Replevin? And why should legal professionals and lenders have it in their toolkit?
Hey, Nathan, thanks for having me today. And I'm really excited to be here. And I'm really excited to be with Tom. I've known Tom for a long time. We've worked in the Replevin space for a long time. A Replevin is a simple word that not many people understand, but it means it's a lawsuit to get a court order to get your car back. So you file a lawsuit, you have a complaint, sometimes you have a motion, but you're asking the court to award the lender an order so that they can go out with the sheriff and seize a car that they've not been able to get through their normal self-help repossession process. And so, why should legal professionals and lenders have it in your toolkit? Well, you're not going to be able to get every car through self-help repossession. Sometimes there's cars parked in the driveway and other cars are parked behind it. Sometimes they're in a fence in the backyard. What we've been able to do a great deal lately is, even without seeing the car, if you know where your customer is, you can file a lawsuit, get an order, and then have the sheriff serve that customer borrower with that order and have the car turned over. So, in a short version, it's got to be part of your toolkit because you're not going to get every car through self help repossession. There aren't even enough repossession agents in the marketplace today. So, it's another tool that you can use to get a pretty valuable piece of collateral that you've not been able to get. And if the alternative is, I'm not going to try to pick it up, then that car is going to continue to depreciate in value while you just not use this other tool in your toolkit.
And to
So,
follow up, if I could,
go ahead,
just on
Tom.
that, really quickly,
Yeah, sure.
Nathan, one of the things that we'll talk more about, and one of the reasons you should come to the Connect in October, is that what Frank is talking about is not what a lot of people think of as a replevin. They're thinking about a statutory replevin. And Frank just made an unbelievably excellent point. You can send the sheriff out there. If you do the statutory replevin, which scares the bejeez out of a lot of people, and you see more in the commercial area than you do in the consumer area, a lot of times that writ that you get is confined to one address. And then you have to go back and get amendments. So the way that Frank has conceived of it and the way that we do it, because we work with Frank a lot, it's a game changer.
So, just before we go on, just for those, you don't have to give away the whole session that you're going to go through at Connect, but you mentioned statutory. What is the difference between a statutory replevin and, uh, you know, just for our audience to know that difference, since this is kind of new for many folks?
Go ahead,
You,
Frank.
well, so in Nathan, a replevin in every state works differently, right? And that's really important to know. As a matter of fact, Louisiana is they have, depending on the provisions in your contract, you have a fast track way to sell a car in Louisiana, or if the language isn't in that particular contract, it really can become quite onerous to sell a car in Louisiana. So the first thing I would tell everybody who's watching today is look at where your collateral is and find experts in those states where your highest volumes are and work with your legal partners to figure out the quickest, fastest, most efficient, and effective way to sell the collateral. So, what we do in many of our states is we don't pursue money judgments. We focus on getting possession of the vehicle. We try to utilize the legal process and not have to do a lot of pre-judgment motions, bonds. We try to streamline it with a simple complaint asking for possession. So again, it's kind of working with your legal partner in a particular state, your higher volume states, your greatest risk states, to create a process from a legal standpoint that's the quickest, most effective, and efficient. That's, I think, Tom, would you agree?
Absolutely, I would agree. And it does vary a lot from state to state. And it's funny that you mentioned Louisiana because the methodology that you and I have embraced so well can't be used there, from what I understand and talking to my friends there. So yeah, you make a great point. It can vary significantly from state to state.
So now we kind of set the table of a little bit of what a Replevin is and how to use it. What are some of the misconceptions or challenges around using a Replevin to recover collateral?
Uh, Nathan, that's another great question. You have prepared yourself really well for today. So I think what scares lenders away from replevins is I think they've either never done them, so they're not familiar with the process, or they've done them and said, "Oh my gosh, I spend all this money in attorney fees and court costs, and I file the replevin, and then we can't even get the borrower served with the complaint to pick up the car." And so that is probably true, but there are ways to avoid that. And so what we've tried to do in my firm and in my programs is we start with a letter series. And part of that letter series includes a letter that's sent second day ground. So we feel like before we ever file a lawsuit, we know where the borrower is. And then the other thing we do is we bill in milestones. And I'm a really big believer in this. I truly believe that lawyers should not bill lenders the entire replevin fee up front when you file a replevin, because a replevin is done in parts. And I believe what's right for the lender and ultimately the borrower is for law firms to bill for the services as they're rendered and as the process goes. So in that instance, if lenders get their cars back sooner rather than later, they're not paying the entire fee up front. If in fact you don't get service and you don't complete the replevin, then you're not being billed the entire fee. So I think one of the biggest obstacles, negatives, bad history is I spent all this money and I'm not getting, I'm not showing the results. And so,
Hmm.
I think I know, not, I don't think, I know there are processes that work. We are really big on ROI and showing our ROI on every single replevin placed with us. And our ROI shows that if you do it the right way, if you do letters up front, if you verify that address, if you bill in stages, then the clients and the lenders and ultimately the borrowers, because in many states the attorney fees and costs are passed on to the borrower, it's a lower amount, and that's a win for everybody. The lender gets their cars back. The borrowers don't have to pay the entire fee up front. It's a win all the way around, and I think that helps get over the hurdles of, oh gosh, I don't know, I've just had some bad experiences.
That makes sense. Thanks for sharing that because I could see where that kind of challenge would or misconception would come from. Before I ask my next question, Tom, any other anything you wanted to add onto the misconceptions of how people see this
Only,
process?
only if you want to learn about the milestones, or as we call them, buckets, you have to come in October. No, I have several clients that do this procedure in the same way, and it's very, very good. It's and Frank mentioned all the positive for the clients. It's actually a positive for the law firms too, because I can tell you the way that the milestones are set up and the way that you're paid for the milestones, you are paid for your time and what you do. And also, if you get into a situation where you get an answer or something gets very, very complicated, then it is not uncommon for those files to go hourly again, so you're paid for your time. So it's like Frank said, it's a win-win. It's a win for the attorneys, and it's a big win for the clients as well.
Hey, Nathan, if I could add one other thing. We ask all of our clients to give us the value of the collateral right up front. And so, at the end of the day, what the client, what the lender wants to avoid, and even the borrower, right, is you don't want to spend $3 or $4 or $5,000 in attorney fees and costs to get back a car that might be worth $7, $8, $9, $10,000. That's not a win for the client. It's not a win for the consumer. And at the end of the day, it's not really even a win for the law firm because you're not going to continue to get work unless you have that return on investment that I talked about earlier. So back to Tom's point, the milestones, I think most clients are really good about paying good fees for good results. And if a
Yeah.
case gets contested, it really is the responsibility of the attorney to step up, tell the client, hey, this is a contested matter. Here's what I think might help get it resolved. Here's might be the fees that are involved, and then live within those budgets. And that helps, it helps the client again and it helps you.
Yeah, I mean that all makes perfect sense, and what I really do love it, and I'm looking forward to the conference and the session, is I love real world stories, real examples, and I know you'll be sharing those case studies during the session, but maybe you can give us a little bit of a preview, one that really highlights the effectiveness of the process. Why don't we go to Tom for that?
I've got a great one. So it really is good. I'm
Just
trying to
one? You've got just one?
one for today. Well, I just had one for you. That was a good
Yes, you
story too.
did.
So we were trying to get a very large, very nice truck back. So I'm in West Virginia, in the city that I have to travel to. This is literally, you have to travel across a covered bridge to get into the town. So I'm there and I park next to this truck, and that's my truck. And I see the guy get out of it. And I said, well, this is going to be interesting. So I go in and I introduce myself to the gentleman. And remember what Frank said earlier. Frank said, we're suing for possession only. So I'm sitting there talking to the individual, and the judge comes out and he goes, Mr. Canary, you prepared? I said, yes, sir. And I said, Your Honor, before we get started, I want to make it clear that the only thing that we're about today is to get the collateral back for non-payment. We're not trying to sue on the note. And his demeanor changed 1,000%. He said, that was the first question I was going to ask you. He looks at the defendant. Did you pay? No. Can you pay? No. Mr. Canary, do you have an order? I said, I do, Your Honor. And I was in and out about that quickly. So the people think that these are very, very complicated things, but if you do it in the ways that we're suggesting, it's not crazy different from what you're doing right now when you're filing your own civil lawsuits, and you can learn some of the tricks of the trade on how to really bring that into your practice, and it diversifies your practice as well.
I mean, it definitely sounds like it's something that can bring in a lot of revenue and new clients, but yeah, you're kind of doing that work already in a certain sense. So it seems like
Yes.
it's a natural fit, which I think is really important.
Yes.
Frank, anything you want to add as far as a war story of yours?
Yeah, so I'm actually going to put a little different spin on it, Nathan. I'm going to suggest all of us need to think outside the box, and Tom knows this because he does work with my network, right? Just real quick, when I started this 5 years ago, the process has evolved, right? And I'm not, for those who know me, I'm not a very patient guy. So most attorneys in most states have to start with a Reg F letter, and when you start with a Reg F letter, then the file sits. And so I looked at that time period where it sat, and I'm like, well, how can I find something that will help during this process where a file sits? And I created something, but you know what? I'm not going to tell you because you got to come to Connect. And then I'm going to tell you one more thing. I think it's really important to think digital and coordinate your actions with your clients. And that, my friend, will be a better story for October.
Oh, well,
Yes, it will.
I'm definitely excited, and I think that's a real cliffhanger. But there is a lot here, and I really am excited about this session. So we're getting close to the end of our cup of coffee, so to speak. So this is the question. We'll go to Frank first on this one. So for those attending the session, what's the one practical strategy or insight they'll walk away with that can make a real difference in their next Replevin action, or in their next case?
Um, Try ways to get the car back without ever having to file the Replevin.
All right, that's a good one. That's a good one. All right, Tom, you get the final word on what folks could expect when they are in San Antonio.
as you're doing and going through this process, especially since we send out our Reg G, our validation letters, we seem to get more responses back to those than we do to the normal lawsuit. Okay. That gives you an unbelievable opportunity to explain to the person what you're doing, that you're not trying to get a judgment against them to garnish their wages or take anything out of their bank account. You understand they've fallen on hard times, but they just can't continue to drive the vehicle for free. And it's amazing to me when I've had those phone calls and you treat people like people and you talk to them like that and you go, you know what? You're right. Here's where you can come and pick up the car. And you'd be surprised. And Frank will have the statistics probably in October of, in these milestones, what percentage of the vehicles you get back with all these milestones. And it's amazing. It's a really, really good process.
Yeah. No, this sounds like really fascinating. And we got to go. It's the end of our episode, but we really want to thank both of you, Tom and Frank, for coming on and championing this practice area. And I think, the closing sentence for this one is, you treat people like people. And that is something that we pride ourselves in this industry to do. But I always say, treat the consumer like that's your mom or your dad. If you wouldn't want them treated that way, don't treat that person that way. And with that, thank you again. Thank you to our listeners, and everyone, have a great day. Thanks.
Thanks, Nathan. Thanks, Tom.
Sure, appreciate it.